We are lucky to have with us today Will Hornsby. He comes to us from Chicago after a 30-year career with the ABA in the Division for Legal Services, for which this year he received the Lifetime Achievement Award, the Lewis M. Brown Award for Legal Services Access. For legal access. He has spent the last few years teaching and consulting in professional responsibility for the tech-based legal services. And I think that tech is something that is always evolving, and it is something that the legal industry has a hard time keeping up with, and that we all struggle with this in our daily lives. So we are very excited to hear what Will has to teach us today. Welcome, Will.
It's being videotaped, so let me just say, please sit. Please sit. Okay, let's start by getting a sense of who's here. How many of you are lawyers? Almost everyone, maybe everyone. How many of you are in-house? Almost everyone, okay. And how many of you are out-house? When they invented in-house, don't you think they think there's a better term for the opposite of that? How many of you are outside? Okay, a few, all right. California admitted? Admitted in other states? What other states? New York? Illinois, Pennsylvania? Okay. I'm sorry? Okay. Is there anyone here who's been involved in the ethics ecosystem, who's sat on committees or anything of that nature? No, so I can make all this up, right? A lot of it anyway. Anyone here ever sent an email? That used to be a legitimate question for me. That's how far back I go. How many of you have ever used email? At any rate, that's kind of an illustration of how far we've come. Just by way of a few housekeeping things, I do have to leave shortly after this presentation. I have another flight I have to catch. But if anybody has any questions that I don't have an opportunity to address, or you'd like to follow up with anything that I'm discussing here, feel free to do that after the conference. This is my contact information. I think it's also on the resource pages. You can go to my website, and I welcome you to follow up with me. Also, if there's anything that I don't explain very well or that you want to add to, feel free to interrupt as we go. I shouldn't say interrupt. Feel free to interject your thoughts as we go along. Just raise your hand and I'll call on you. I typically don't do a very good job of saving time at the end for Q&A. We may have some, but typically not so much. That's our interactive portion of the CLE program. I think, does that qualify for the interactive portion? Okay, good. Let's get to it here. So the issues that I want to discuss today, well, first of all, I'll go through a little bit on the ethics ecosystem, how the rules are made, how they're interpreted, what our resources are on that. And you'll find a good number of these rules and ethics opinions in the handout material or the archived materials accompanying the program. Then we'll look at some of the ethics issues involving email. Some of them are longstanding, some of them continue to emerge. And then a very central part of our conversation will be confidentiality within the within the realm of tech communication. We'll spend a little bit of time on artificial intelligence, a little bit of time on blockchain and cryptocurrency. Is there anybody here who feels comfortable explaining what blockchain is? No, I don't, for sure. I'm probably one of the lesser technologically adept people in the room, but well, I think it's important for us to be aware of this. Then we'll follow up with my technology hall of shame and some examples of what people should definitely have never done. So let's talk about how ethics, how the sausage is made with within the ethics ecosystem. As many of you, I'm sure, know the ABA issues a set of model rules of professional conduct. Those are the rules that do nothing, essentially. They provide this, I shouldn't say they do nothing. They provide the states with guidance on what the ABA believes ought to be the ethics of the legal profession. In and of themselves, they have no force and effect. And I think that's a very important thing to understand. I talk to lawyers all the time who say, yeah, but I'm compliant with the ABA model rules. And I say, yeah, but those rules are different in your state, and your state are the ones who will discipline you for failure to comply. They won't discipline you for failure to comply with the ABA model rules. They'll discipline you for failure to comply with your state rules. But the value of the ABA model rules is that they provide a basis for states to start their conversations about what the states believe to be the appropriate rules governing the lawyer's conduct. So we've had a couple of special entities over the last several years that have revisited the model rules. The model rules, incidentally, were adopted in 1983 with black letter rules followed by comment, and that continues. In 1998, the ABA started an initiative called Ethics 2000. Some people thought that meant that the initiative would last for 2,000 years, but the goal was to amend the rules by the year 2000. Actually happened in the year 2002, and there's some changes that I will share with you as a result of that. The changes were not necessarily profound, but impactful at the same time. And then in 2010, the ABA launched an initiative called Ethics 2020 that resulted in some rule changes in 2012. And so what this means is that the states continue, even though the model rules are designed to create a harmony between the states, a uniformity, actually these rule changes have complicated that, and so some states have certain rules that are newer ABA model rules, while other states embrace the older rules, and I'll show you some examples of those. So the gateway for the ABA to develop its model rules is through its Standing Committee on Ethics. It's a very small committee. I believe it's either 9 or 11 members that are presidentially appointed for 3-year terms. And then when they come up with a rule change, that goes to the ABA House of Delegates, which is literally the size of Congress. It's 535 or so delegates from around the country, and they give an up or down vote on resolutions to change those rules. So it's relatively difficult to have rule changes, but it does happen from time to time. And so the result is we have no two states have the same set of rules. California adopted some significant revisions to its rules last year after only considering these issues for 20 years. And California became one of the last states to conform to at least the ABA architecture. So we have, confidentiality is 1.6 in almost every state now. Client development is 7.1 in almost every state. So we have now this architecture where you can find rules that are collateral to the ABA model rules relatively easily. Model Rule 8.5 was adopted 12 years after the rest of the model rules. It's a choice of laws rule. It determines what jurisdiction governs the conduct of a lawyer, notwithstanding admission, and it determines under what rules those are governed. Does anybody have any idea of why this is the last model rule? It's because when the ABA adopted the model rule, it just assumed every state would adopt every model rule. and there'd be no need for choice of laws. There'd be no need for determination of which state rules apply. They'd all be the same rules. And after a little more than a decade, we figured out that that wasn't going to happen. And so the ABA adopted this, this rule making that determination. California, as I'm sure many of you know, is also governed by the by statute, by the Business and Professions Code. That's uncommon in the states. Many states have legislative provisions that govern the conduct of lawyers in some way, but not nearly to the extent that it's done in California. And that's important to understand too. So how do we determine, when we don't really understand the application of the rules to a specific fact pattern, how do we know what that is? We go to ethics opinions. And the ethics opinions interpret the rules to fact situations. They're not binding, as the rules are. You won't be disciplined for failure to follow the advice of an ethics opinion, but to the extent ethics opinions are adopted with some degree of wisdom, it would be probably foolish not to follow that course. Different states and bars sometimes come to different conclusions addressing fundamentally the same fact issue. There was, a few years ago, there was a question of whether lawyers could participate in Groupons. I don't know why a lawyer would want to participate in Groupons, but some of them started doing that. And there were about 12 states that issued ethics opinions as to whether or not this was proper. 5 of them found that it was, and 7 of them found that it wasn't, determined, I shouldn't say found, determined that it wasn't, even though the analysis were fundamentally the same as they went through the scrutiny of the application of the rules. So different states will come up with different conclusions. And when we look at ethics opinions, we need to look at whether or not they're opining on the same rule, because sometimes there'll be a subject matter that will have a distinction in the states, and I'll show you some examples of that in a couple minutes. But fundamentally, ethics opinions serve as a guide for that. Anybody recognize this handsome guy? His name is Lawrence Cantor, and he's attributed to being the alpha spammer. Lawrence Cantor figured out how to send mass emails through technology with great efficiency and convenience, and that led to spam. And when I was at the ABA, I'd get calls from people who were upset about this. And I said, well, what exactly is the problem? They'd say, it's a breach of netiquette. Okay, so I'm guessing netiquette is the ethics of the internet, right? And I was not very sympathetic to them, not as much as I should have been. But the fact of the matter is, he came up with a technological solution to something that he wanted to do, broaden his base of advertising, his services essentially, in a way that wasn't necessarily a violation of the rules, in at least the ABA model rules, but he was sanctioned where he was admitted in Tennessee on 3 little technicalities. He called himself an immigration lawyer, and at that time Tennessee had a rule that said you couldn't call yourself an immigration lawyer. He didn't file the communication with the state, which was a requirement there. So he was actually suspended for a year. It was aggravated by his failure to defend. But the fact of the matter is they came up with some very technical violations to accommodate the interest that they wanted, which was to prevent lawyers from spamming, even though the rules had not caught up with that. So now we have some tech-based rules that I think are helpful, and I'm going to come back to some of these, but very briefly, the ABA amended in Ethics 2020, the ABA adopted 2 amendments that directly go to technology. One of them is a comment to Rule 1.1, which is a rule on competence. And it says a lawyer shall keep abreast of changes to the law and its practices, including the benefits and risks associated with relevant technology. So basically that's telling us we need to know something about technology. There was actually a lawyer sanctioned because she didn't have email. And the state had required people to register through email. And she didn't have email. And they brought disciplinary action against her, claiming that she was refusing to keep up with the technology. And so she opened a Gmail account that said something, that URL was something like, the state bar sucks and made me open this account Gmail. So at any rate, we do have this responsibility, and it's not a serious burden, but when we look at the change to Model Rule 1.6, it says the lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of access to information related to representation. And so the key here is the term reasonable, and I'll talk more about this in a couple minutes, but it's important that we consider what actions are reasonable. California has not adopted either of these, but there's a California ethics opinion, which is cited in the material, that says a lawyer has a responsibility to take appropriate steps to prevent disclosure. And it does not subject appropriate steps to make sure that information is not subjected to undue risk of disclosure, is how it states it. LA County Bar opinion has to do with pretexting. How many people are not familiar with the term pretexting? A few reluctant ones. Okay, very simply, pretexting is pretending you are something you're not. It's best, I sometimes include it in this presentation, but I didn't do so today. It sometimes is focused on, it's best illustrated by the New Yorker cartoon where there's a dog at a keyboard and says, "Nobody knows you're a dog on the internet." Well, people don't know who you are on the internet. And if you don't take steps to verify that identity, you're subject to the wrongful actions, contributing to the wrongful actions of someone else. By the way, before I go any further, I just want to say that different states have different quality of ethics opinions. And there are state ethics opinions, and many times major metropolitan bars have ethics opinions. So there's San Francisco Bar, the LA Bar, the San Diego Bar, and they're very well done. They're clear, I think, they're clear and pointed and reasonable, which is not true of every state. So those are a valuable resource to you. So I kind of developed this notion of how we deal with our problems with technology. And so the first one is, shame on me, and I'll show you examples of all of these. I should know better, right? When I use technology, I should know better than to have done this. And the second one is, it's a little complicated, and this is where people need to have help in their use of technology. And the third one is, I'm really a victim here, and this pretexting is an example of that. So let's dig down a little bit on emails, and it is the most common use of technology. It is something that is subject to problems because we sometimes just don't pay attention to it. And you clearly here, as these headlines show, it's a large firm problem, and so it's a problem at every level of practice of law. So the issues I want to look at here involve inadvertent disclosures, blind CCs and reply all, metadata and redactions. You may have seen redactions in the news recently, and something called web bugs. So in terms of inadvertent disclosures, one thing Has anybody ever had this happen where you start to type in who it goes to, and then you just, it automatically fills in, and it actually fills in to be the wrong person, right? I think I'd be surprised. When I fail, like lots of times I'll send something out and forget to make the attachment, and they'll say, where's the attachment? I say, oh, that never happened before. Happens all the time, right? And I think this happens too. And if you're dealing with critical, sensitive information, this is an easy function to turn off. It makes things a little more difficult, but it's clearly a protection that's of value to the client and something that you should consider. So another thing are blind CCs and reply all. Alaska has a recent ethics opinion that says you should avoid CCing clients on emails with opposing counsel, and it establishes protocols for that. And the reason is that your client may be even less sophisticated of a user as you, and reply and not know the difference between reply and reply all. Have you ever gotten a message that was meant for an individual, but they replied all, and everybody got it, including the blind CCs? That's something that we need to avoid. And so Alaska, for one, just says, yeah, don't include the client on the CCs. Don't go there. And again, it makes it a little more time-consuming. It makes it a little more inconvenient. If you want to send something to a client that you've sent to opposing counsel, you should do it separately, and you reduce, if not eliminate, that risk that's going to happen. So, duty to notify. In 1992, the ABA issued an ethics opinion that said that if you get an inadvertent disclosure, you have two obligations. One is to stop reading it the instant you recognize it was not meant for you, and the other is to notify the sender, not only that you received it, but the circumstance of that receipt. When I was at the ABA, I would get calls very frequently from people who had inadvertently faxed something to the wrong person. And the caller was generally the person who had done that, not the recipient, right? And so they've discovered it. And in that era, in the 1990s, early 1990s, before the internet was much of a thing, there'd be files, right? And there'd be the contact information. And typically, the lawyer would say to an administrative assistant or paralegal, fax such and such over to the client, and they'd get the numbers mixed up. They'd look at the space, and maybe somebody wrote the numbers down wrong, and they'd wind up sending it over to the wrong party. So the ABA ethics opinion said duty to notify and duty to avoid reading. The interesting part of this ethics opinion, as opposed to any other ethics opinion I've ever seen, is it was not predicated on any rules, because there were no rules governing this at that time. And so they just kind of did an analysis of a moral dilemma here. What's the proper thing to do, basically, right? And so they came up with this, and then after that, the ABA amended its Model Rule 4.4b that requires notification, but it does not require you not to read the information, okay? California's corresponding rule, adopted last year, and frankly, I don't know if the rule predates that, but it is both notification and refrain from reading. Now, here's why this is an interesting, and the formal opinion that I cite here takes the same approach. Notify the sender and refrain from reading. Here's what makes this interesting. Under the ABA model rules in the states that have adopted the ABA model rules, most of them have an obligation under the comment to Rule 1.3, which is diligence, to have zealous advocacy in the representation. So under the ABA model rules, it's consistent to notify But if you refrain from reading, are you providing zealous representation for the client? It's right there. It was sent to you. It was given to you in some manner, right? You don't have to dig it out. It's right there, right? And so there's this conflict among the states between the ability for you to read it and perhaps the obligation under ABA model rule states compared to California and other states that have adopted this position that say you must notify and refrain from reading further. Even if you had an obligation for zealous representation, it still stops with this provision that you refrain from reading it. So this is one of the kinds of examples of how technology is difficult for us to apply and comply with the rules because we have these distinctions. So that's inadvertent submissions of transfers of information. We also have metadata, and metadata is basically something that allows you to see using technology what you can't see just looking at it, right? And so this involves a process of searching. So, for example, if there are negotiations between a firm two firms, right, and they're using a document that's just like a Word document, right, and they're marking it up and exchanging it, right, and then there may have been other people in the firm who were involved in that discussion and marking it up. And so there may be invisible information invisible to the naked eye that has to do with those terms, right? But you as the recipient of that can determine can see what that information was, so you know where they were going in that. This is a difficult area, but this is why the ABA adopted that rule, saying you have to be aware of technology so that you can prevent doing that. So this is one of those bad on me kind of examples. So redaction is something that has been abused, and you may have seen this in the news lately, and I'll show you the example. Manafort's lawyers filed redacted material. People familiar with this? Yeah, it was in the news. I actually did this, right? And so if you go to the filing, you still do this to this day. If you go to the filing and you cut and paste the blacked out part and you take it from the format that it's filed in and you put it into a Word document, ta-da, there it is. And a major law firm is being sued by its client right now for having done the exact same thing. And so this is one of those things where it's complicated. And maybe as lawyers, we're not trained to be able to do this, but we need to have the assistance of the people in technology who are, to enable us to further comply with that obligation of taking reasonable measures to make sure that the technology is used appropriately. Web bugs. Web bugs in this, I'm sure there's all sorts of web bugs, but these are tools that are used, in this opinion, that are used to determine whether or not your email, whether or not, let me back up, tools used for a sender of email to know whether or not the recipient opened that email. So, for example, when you guys were planning this conference, you might wanted to know who acted on your invitation, right? And if you had a web bug, you could determine, 74% of the people opened it. If there are people you wanted to make sure got the information but didn't open it, you can address that separately. Well, the same thing in litigation and in practice issues. you might want to know. Well, lots of times I'll send a memo to someone, and and they're too busy to reply and say, yeah, I got it, thanks. Lots of times they do, but sometimes they don't, and I'm sitting there wondering, did they get it? You know, and so this is a matter of convenience. But the Illinois State Bar Association says that this kind of tracking software is an unwarranted intrusion that's deceitful, and so they prohibit the use of that. Any questions on anything I've talked about so far? Yeah. I don't know exactly how a read receipt works, but is that is it visible to the recipient? Yeah, I think that's the difference. Yeah, and this one, they talk about how the recipient doesn't have any interaction with it, doesn't even know it exists. Okay. Any other questions? Okay. Let's talk a little bit about technology and confidentiality. The rule governing confidentiality is 1.6 in the ABA model rules, and it's collateral for the great majority of states. Talk about the difference in this unit. I want to talk about the difference among state rules, cloud issues, what do you do if you've been hacked, and some social media issues, some issues that are specific to social media. So, as I mentioned, 1.6 has two provisions that we should note here. The fundamental provision is a lawyer shall not reveal information about the representation unless the client gives informed consent. Okay, so the informed consent is always your hook. It's always the lawyer's hook to be able to otherwise reveal information about the representation. So the way to think about this, and for those of you who are clients of legal services, the way for you to think about it is you own this information. This information from your lawyer is yours, right? And so you should be the one to govern its dissemination, not the law firm, okay? And so informed consent means that the law firm should give you information about possible adverse consequences of revealing this information, okay? The second thing that I mentioned a moment ago is a lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of information relating to the representation. The key here is reasonable efforts. We'll come back to that in a second. So there is an earlier version of Rule 1.6 on confidentiality that says a lawyer shall maintain the client's secrets and confidences. And again, subject to the client giving informed consent. So which of these is more restrictive? The prohibition against revealing information about the representation or the obligation to maintain secrets and confidences? How many think it's the prohibition against revealing information about the representation? How many think it's secrets and confidences? Okay. I think you guys who voted for the first one are right. I think the obligation to maintain information about the representation is broader than a secret or a confidence, okay? Now, we may be splitting hairs here, but I think that this is now the majority view. I think that this is a broader obligation. And we'll talk a little bit about publicly known information in a second as well. California's Business and Professions Act governs this as well as its ethics, and it says a lawyer must maintain inviolate the confidences, and at every peril to himself or herself preserve the secrets of his or her client. I think maintaining inviolate the confidences is broader than is more is a greater obligation on the law firm, let me put it that way, than prohibition against revealing information. I think that is the most restrictive part that exists. California Rule 1.6 is the same as the ABA model rule unless the client gives informed consent. But in California, there's no counterpart to ABA model rule 1.6 regarding reasonable efforts to prevent the inadvertent or unauthorized disclosure. But you still have that obligation to maintain that confidence to the best of your ability. So let's talk for a minute about cloud computing. Cloud computing's a matter of economics for preserving data. Your data is not on your computer or your server, it's on someone else's server. Your server is how you get access to your computer, is how you get access to it, and it's an interface where the magic happens. So these are examples of cloud computing platforms that we typically use in different manners. And some people have a notion that cloud computing is that information on the cloud is not appropriate. It doesn't meet our standards, but in fact, it can very easily do so. So where's the data? The data can sit on servers anywhere, right? And where the data sits is really not the relevant part of it. The relevant part of it is whether or not we as lawyers are taking reasonable efforts to prevent the inadvertent or unauthorized disclosure of the information. So what's reasonable, right? Reasonable is not a guarantee. Reasonable is not perfection. We have to take reasonable steps to prevent the inadvertent disclosure of this information. And so when you're dealing with a cloud provider, what are the questions to ask? And I've got a series of slides here, and I'm not going to go through all of these because it's way too boring, and they're in your materials. If you're in a position to weigh in the decision-making of the use of legal information, whether you're in-house or not, to reside in the cloud, these are some of the questions that you should ask, and a friend of mine actually assembled these questions who's much more technological than I am, but I'm just going to highlight a few of them. You want to get references from entities similar to yours if you're dealing with a cloud provider. You want to know, do they subcontract this work? Does it go to somebody else? There's actually a legal cloud computing association that has security standards. Do they comply with those security standards? Does the cloud software let you customize security for your firm without having to choose from predetermined options? Is there a feature that enables you to do that, if need be, to provide your protection? So those are, so here is a list of 15 or so things that you should ask when you go through that decision making. So what if you're hacked? I'm the victim here, right? It's beyond complicated. I'm the subject of abuse, but is that a comfort to a client? I don't think so, right? Or a customer, for that matter. So here's what we know. First of all, to comply with 1.6c, you have to take reasonable measures to prevent, reasonable precautions to prevent this from happening. So did you have preventive measures in place? Second of all, it's really all hands on deck. The lawyers, the technologists, if it's a business setting, anybody who's involved with this needs to all be on the same page, right, as to what you do. And third, ABA formal opinion 483 says that there's three basic things you have to do. You have to notify the client or the customer, right? Second, or in this case, the client. Second, you have to investigate, how did this happen, right? Why weren't our reasonable measures successful in preventing this, right? And the third thing is you have to mitigate. So what measures do we now need to take to make sure that we address the problem as effectively as we possibly can from a technological point of view, and what measures do we need to take to make sure this doesn't happen again, and to give our clients that source of comfort, okay? So let's talk about social media, because I think, well, let me ask you, how many of you are on LinkedIn? Almost everyone, okay. How many of you tweet? Not that many. Can you raise your hand high if you tweet? That's interesting. Personally, I find Twitter to be a great professional resource. I get a lot of information about research and studies that are being done there. But what I'm seeing in terms of your hands being raised, it's very consistent with what I've seen in other places. I think it gets a bad name for obvious reasons. At any rate, anybody blog here? Any bloggers? A couple, okay. In-house or outside? Do you blog in-house or do you blog as an outside? Let me put it this way. Are you blogging in your capacity as a lawyer? No. Personal? Yes and no. Okay. All right. And you who say yes, are you doing it as part of your job or ancillary to your job? You're doing it as part of your job. Ancillary or part of? Part of your job. Okay. All right. Interesting. And then I'm going to talk for a minute about client reviews. So, DC ethics opinion, there's two opinions, 370 and 371. These are excellent opinions on the use of social media and the cautions that you need to take. Exercise caution when social media sites request permission to access your user email. And that's just one of a litany of things that these two opinions approach, and I think that they're really important parts of that. Hold on a second. So I think LinkedIn has some interface issues that you want to be sensitive to, information that they ask for different levels of profiles. So you just want to make sure that you understand what they're asking for the use, for you to be able to use these. So let's talk about blogs for a minute. How many of you read blogs with some consistency? You don't write them, but you read them. Okay, good. And much of this, I think, also applies to podcasts. I think podcasts are fundamentally a verbal audio version of a blog. By the way, I just saw that the first legal blogger started 25 years ago. So there's a full generation of blogging that's gone on. And it's a profound impact on legal journalism. So the things that we want to look at are thoughtless breaches of confidentiality, positional conflicts, the firm's duty when a member has a personal blog, and so those are the things that I think are important in this respect. I'm going to come back to the thoughtless breach of confidentiality because I think I have something that's a really good example of that. But positional conflicts. So if you blog about something and you take a position on it, does it have an impact on your client relations? Does it have an impact on your relations with law firms and lawyers that you engage? We are free to have political discourse, and we commonly do. But when we express that, is that boxing us in a certain way that we want to think through before we actually assume those positions? what's the firm's duty when a member or associate employee has a personal blog? So there's two ethics opinions on this, at least. California opinion 2006-196 says that if you have a blog that's part of your website, and this focuses on advertising actually, so it's a little misdirected, I think, in terms of confidentiality. But if you have a blog that's part of your website, they say that that's an advertisement and subject to those rules. But if it's a standalone blog, then it's not subject to the rules. But I think they miss the point, don't really miss the point, but they don't address the point that it's still subject to rules governing confidentiality. And so we need to be sensitive about that. ABA Formal Opinion 480, I'll talk about in just a second. So I know you can't read this, so I'm going to read parts of it for you. But this is an ethics complaint against a lawyer in Illinois. And there's a well, let me tell you what she said first. She started blogging, and she was a public defender. And she started talking about her relationship with her clients, and she started revealing information about the clients. And so she tells these stories, the backstories of her representation. So she defends drug dealers, and she tells this, she blogs about this one particular guy who was using in breach of his court-ordered obligation, and she tells another story about a guy who took a fall for his brother, and things like that, admitted guilt for something his brother had actually done. The backstory here is that this lawyer had been assaulted by one of her clients as a public defender, and went into counseling. And her counselor, as counselors tend to do, said, talk about it, get it out, right? And so they decided maybe blogging would be a good way to talk about it, right? And so she created this blog. Neither one of them had this notion that it was inappropriate to do this in terms of breaching confidentiality. Just something that did not enter into her psyche. But it did enter into the notice of the Attorney Registration Disciplinary Commission, and she was sanctioned for doing this. This is kind of shame on me kind of approach, just something that was thoughtlessly done without a concept of compliance, obligation to comply with the rules. So ethics, ABA opinion 480 talks about blogging, and there's an interesting part of this. It says lawyers who blog may not reveal information relating to the representation, including information contained in a public record, unless authorized by the client to do so. So the irony here is, if a law firm represents you in a matter and is your lawyer of record, right, and there's public information about that, a lawsuit, for example, right, your obligation, the lawyer's obligation for confidentiality, is to not reveal that. Whereas it's a public filing, and every other lawyer in the world can reveal that information. So we struggle with this notion of how far confidentiality goes in terms of our application for confidentiality, in terms of the application to the technological facts. So, client reviews. Now, I know that the folks in this room are typically not subject to client reviews. The law firm's not typically subject to client reviews. But this concept of Yelp or Google reviews or so forth, I think is something that's going to expand. I think that there are people who are going to move forward with this and communicate more and more about their representation. And I think this is especially true when millennials get to be in more of a decision-making role. And so I think that, so I think this has some relevance to all of us. But here, this is a case that involved another Illinois case that involved a lawyer who decided that a review was unfair to her and that therefore she should, and I think it's Yelp, therefore she should respond through Yelp and go into the facts of the matter. And that's a breach of confidentiality. Now, you're never going to get a client, I shouldn't say never, but it's unlikely you're going to get a client who agrees to this and an informed consent gives you the opportunity to respond. And if you do respond and you say anything other than, I'm sorry for the way you feel, and even that sometimes is problematic, I think you have to be very cautious about public responses to criticism. Whereas a private response, call the person up and say, gee, I was disappointed to see that. I'm sorry that it didn't work out for you. If there's anything, any way I can make this up to you, let me know. That's probably the course to take. But public response to something that's adverse is just inappropriate under that confidentiality obligation. So this is a tweet that came up about a year ago. The person from the law firm says that I can confirm that this law firm and Ted Olson will not be representing the real Donald Trump. Okay? Breach of confidentiality or no? How many of you think that this tweet is a breach of confidentiality? How many of you think it's not? Most of you don't. Okay. I think there's two possibilities here. One possibility is the real Donald Trump nor anyone on his behalf did not contact the firm to inquire about the representation. When that's the case, I think it's perfectly fair to tell the world you're not representing him, right? But if the president or someone on his behalf did contact the firm about the representation, we have an obligation under Rule 1.18 to prospective clients. Prospective client is someone who reaches out to consult about the prospect of representation, whether or not it actually takes place, okay? So our responsibility under 1.6 is to our clients, but our responsibility under 1.18 is to our prospective clients. And therefore, if somebody from the president's office or the president reached out to this law firm, and this law firm is saying that we are not representing this client, that quite likely is a breach of the duty to a prospective client. So, any questions about confidentiality issues? It's really some sticky areas here. There are really some sticky areas here and some problematic things. There's a concept that, yeah, I'm sorry.
Could you speak to why there are ethics issues arising from disclosing information that's been publicly filed?
Yeah.
Because those are, in California, there's a qualifier for those, at least with regards to clients.
Right. Yeah, the question is, why is there an issue with disclosing confidentiality of something that's been filed? And this is in ABA Rule 483. I'm sorry, ABA Rule, I think it's 480, but it's one of the rules in your material. It does go into this a little bit, and it's not a very satisfactory analysis, in my opinion. And this is part of the progression from secrets and confidences to information about the representation, and whether or not information about the representation and under the California code, holding inviolate confidential information is all kind of a progression toward protecting the client. And so it does create this irony, as I said, where other lawyers can use public information, but lawyers can't do it without consent. I know that there are certain corporations that will not regularly give consent because they believe that it's embarrassing for them to be involved with some of the things, the litigation against them, for example, and they just don't want there to be public conversations about whatever those issues are. I frankly think that there's some constitutional issues with that prohibition, but that's just the interpretations that have been made on the perhaps illogical extension of that rule. But it's just, like I said, from the client's perspective, the client is the one that holds that information, that holds the rights to that information. And so it's just the utmost extension of that right. I know that's not a very good answer, but I don't think there is one that's particularly good. Anything else? You're just scratching your hair? Okay. Yeah, all right. If you were in an Iowa town hall, you would have just voted for Bernie Sanders. Anyway, so there's this notion that's arisen that lawyers ought to Google their prospective clients. And I don't know if that's a good idea or not, but I think that for certain types of practices, there's some value to that notion. And so for you who are clients of legal services, know that people are looking into using the internet to determine who you are, what you do, and where you're going with things. I sit on a board on the hearing panel for disciplinary complaints in Illinois, and there was a pro se respondent who went through, who in his opening statement went through information about each of the 3 panel members that he got from the internet that made me feel very uncomfortable, because we're judging this person's behavior, and he's telling us that he knows about us from what he found on the internet. Not that any of it was inappropriate, but it just created a really kind of bad vibe with us. But I think that in terms of a client relationship, there's something a little more to that. Artificial intelligence. So we have chatbots, we have predictive technology, we have document preparation, data management. Obviously, the threshold AI has been in the e-discovery area, where the technology creates great efficiency and perhaps enhanced performance that better enables us to do that. But what we're seeing now is, I think, more advanced with that, and we're seeing, anybody dealing with chatbots in their businesses? Automated Q&As for customer service and that sort of thing. You go online and there's a pop-up, you want to talk about this, then you ask a question, and if there's a stock answer to it, they'll give you a stock answer. If there's not, they'll send you over to somebody who pretends to be whoever they were to start with, that sort of thing. This is an example, and again, I know you can't see it. This is an example of a chatbot that was created by a law firm that represents landlords in the Chicago area, and it just walks people through the process, and it's pretty sophisticated how they've done that. Anyone have any of these beasts in their homes, in your home? In your office? Good. What's their goal, right? Is their goal to tell you whether you need an umbrella? I don't think so. Wait, did I miss one? Yeah. She spies in our homes to train her AI, all of our questions, and even fart jokes. Amazon employees get to listen. Your voice now belongs to Amazon. It's kind of a doomsday scenario, but the fact of the matter is that they're subject to abuse with this information. And I can see certain circumstances with client development where people have these in their homes and they become proactive, right? They have anticipatory delivery. And so there'll be, so a husband and wife will have an argument, right? And not talking to this thing at all, right? And then there's a silence and you hear the wife crying, and Siri comes on and says, Jane, I heard you and Tom arguing again. Would you like me to recommend a good divorce lawyer nearby? Or they listen, they hear the phone call from the bill collector, right? David, I just heard you talking to another bill collector. Would you like me to connect you to a bankruptcy lawyer? So that technology exists. Right? This is not Tomorrowland, right? That technology exists, and our restraints are rules, basically. So here's some interesting examples. This is a website that never actually took off, but the idea was to combine marketing legal services with your Facebook, because we know that the next best thing to having an in-person testimonial is to have a recommendation, right? And so from somebody you know, right? So this is a method of connecting a search for legal services, in this case, street law kinds of services, with your Facebook friends or LinkedIn friends. It could be any source that they can tap into that allows you to get information about whoever they may have used in that respect. So here's an example of this. When I love to go to New Orleans because of the food, okay? And when I go there for more than 2 days, I always go to a restaurant that I've been to and I can trust and I know I love, and I always try a new restaurant. So I go on TripAdvisor to look for new restaurants. So one time I was on TripAdvisor looking for a restaurant in New Orleans, and up pops this pop-up that says Norm Rubinstein what's it say exactly? Norm Rubinstein are friends with a reviewer of this restaurant named August. So Norm Rubinstein is somebody, a colleague that I've worked with, had interactions with over the last 20 years. He is one of the most elegant people I know. Norm is just graceful and distinguished, and I trust his opinion without a doubt, okay? And so for him, for this restaurant to have some affiliation with him makes me think of it differently, right? And so even though it doesn't say Norm liked this restaurant, all it says is he's connected to somebody who reviewed it. It doesn't even say that the person who reviewed it liked it. And by the way, I didn't like it so much. But at any rate, this changed my perspective. So imagine for legal services, right? Imagine you're searching for legal services and up pops something from somebody you know, you trust, you value the opinion of. You're going to think of that law firm differently. And so, again, this is technology that currently exists. So let's talk social seating. Anybody familiar with social seating? Okay, you are? Yeah? All right, if I get this wrong, let me know. So there are airlines, and I don't know if this still exists or not. I don't know if this was a success. But there are airlines, when you book a trip, you can see if anyone in your LinkedIn account is also on that flight. And you can select a seat next to or near them, all right? So those of you who are purchasers of legal services and you just happen to be next to a decision maker in a law firm that might be looking for your business, and they innocently say, hey, what do you do? And you tell them, and they say, what a coincidence. And by the way, we have 2.5 hours to talk about this because I arranged to sit next to you. So it's this is the kind of thing that technology is driving us toward. So AI issues. So these issues are complicated, right? So are they consistent with our competence, right? Are we using AI in a way that allows us to be familiar with and take reasonable actions? Are there confidentiality issues with this? And certainly with the use of the Siri type and Alexa type of interactions, there are. It's not just, do I need an umbrella, right? And there's a duty to supervise. So if you have, if you outsource a chatbot, for example, you have a duty to supervise the assistance that you're having on that. And then, of course, AI has a tremendous impact on billing, right? Because this causes us to shift to the value of the work from the time that it takes to produce that work. And so these are things that are down the line. And incidentally, I think that the legal profession doesn't pay enough attention to technology as opposed to legal technology. We look at legal tech constantly. I mean, there's one conference after another. There's probably a conference every week of the year that has to do with legal tech, right? But we don't think about what is the impact of autonomous cars, right? What is the impact of our interaction with Siri and Alexis? What's the impact of technologies that are emerging? And all of these things, I think, are going to have a profound impact on our legal needs and our ability to access providers for those needs. And I think that, as we look toward the future of these sorts of things, we have to be really more focused on the changes that are taking place as a result of technology in the population, as opposed to just technology that supports and advances the services that we provide and that you access. So blockchain. Did anybody come in the room late that knows blockchain or cryptocurrency? Okay, so it's an open distributed ledger that's best illustrated by cryptocurrency, which is best illustrated by Bitcoin, which is, as far as I understand, an opportunity to lose your money very quickly. I don't know. Could be wrong about that. Anybody buy Bitcoin? Anybody own any Bitcoin? How's it doing for you? Yeah, well, thank you for helping me prove my point. Not only, I'm sorry? Yeah, you bought high. Well, who knows over time, right? You still holding? Yeah, hold when it goes down. There's actually over 2,300 other currencies that are part of blockchain. But seriously, blockchain beyond cryptocurrency has a certain value to it because it so far cannot be hacked because it's distributed, right? And so land title, for example, isn't centralized, and therefore nobody can hack it and create a scenario where somebody else owns that property because there's all these different interconnected points where that just chain of distribution is demonstrated and connected. So in terms of the practice of law, I think there's a couple things about cryptocurrency that are important. One of them is that there's been a Nebraska opinion that says if you receive you may receive cryptocurrency as a form of payment for legal fees, but you should cash it immediately upon receipt. Now, I don't know if that's just a pragmatic thing or what, but it's inconsistent with those concepts of being paid with stock, of being paid with other things of value that are not currency. There's not prohibitions on that, and you can certainly receive and hold stock, and there are actually people who have been paid with stock that have swim or sunk, but some people have done very well holding stock that they've received. And I'm not sure exactly the explanation, I'm not sure the explanation for this is very good, other than the fact that if it may not be consistent with our boundaries of receiving fees, depending on its fluctuation. It may be something that makes our legal services, makes the compensation for our legal services too much, or may be detrimental to the client. But I think the other reason why it's important to have folks who know this is because you could have client assets with cryptocurrency. So law firms that are providing estate work will have clients who, as part of their estate, are holding cryptocurrency. But fundamentally, this is my observation on this. Everything you don't understand about money combined with everything you don't understand about computers is John Oliver's take on Bitcoin. So that, I think, reflects my notion of that as well. Any questions on social media and artificial intelligence? Okay. Let me talk for a minute about some really bad ideas. Not necessarily ethics issues, but things that people have done. There's this sense of irresponsibility in communicating on the internet. We see that every day at the highest levels of government. But it's just pervasive, and I don't know why it is and why people think that they ought to be able to say the things they do. And so obviously the remedy for this is to think before you send. And I think, I know this has been true of me at different times where I've had this kind of hostile reaction in my work. And I'll type something that's hostile and not altogether productive. And I think to myself, then I step back before I send it and I say, is this a good idea? Is this going to help me? Is this going to help my client? And typically no. But these people didn't think of that. So it's a really bad idea to use Twitter to encourage killing people. And this is a story about a deputy attorney general. You all may remember, this probably goes back about 5 years now, where there were mass protests at the Wisconsin State Capitol in Madison. And protesting the governor and certain actions that were taken there. And people basically raided the Capitol and they would not leave for days at a time. And so Mother Jones, the progressive magazine, said that sources in Madison say that police have been ordered to clear protesters from Capitol at 2 a.m. And then this guy from Indiana thought it was a good idea to retweet that with the addition of "use live ammunition." Well, not only did he think that was a good idea to express his own opinion, but he thought it was a good idea to do that from the Attorney General's office's computer. So that was the basis of his dismissal. It wasn't that he said it, because he had a right to say it. He had a political discourse to say that, but he didn't have a right to say it using the government's computer. It's probably a bad idea to blog that the judge is an evil, unfair witch. I'm just guessing, right? So here's a lawyer, I think he's from Florida, who used that exact phrase in a blog about a lawyer. When I practiced downtown, I had an office that was about 2 blocks from the courthouse. And I would frequently meet my clients there and, go over whatever the case was, and then we'd walk over to the courthouse together. So I have this vision of this lawyer walking over the courthouse with a client and saying, if the judge seems a little upset with me today, maybe it's because I was blogging that the judge was an evil, unfair witch the other day. I don't know. How do you explain that to a client, right? So it's probably a bad idea to create a fake Match.com profile for opposing counsel. And this is a recent one, and I just don't get it. This story just doesn't add up. But there wasn't really a romantic relationship or anything between these counsels, but this lawyer, apparently just for the fun of it, created this awful Match.com profile of a woman that he had had cases with, in several cases at that. And he had, he included organizations that she belonged to, including weight management organizations, and just like, it was just credible enough, but it was really offensive. And she just found it and she didn't even know it existed, and somebody said, gee, I saw your profile on Match.com. That was kind of harsh. And she's like, what are you talking about? And then they went through this process of tracing it back to who actually entered this information, and it was just horrible. And I mean, why would you do that? I just don't understand, but nothing lawyers do surprise me anymore. But it's probably a really bad idea to be texting to minors. This is a prosecutor from Champaign, Illinois, who started a relationship with a woman, a young woman, a teenager, who he was whose office was helping protect from domestic abuse. And he started hitting on her on the internet. And one of the things he texted her was he actually took her to a state conference of prosecuting lawyers as his plus one. And one of the things he texted was, oh wow, you better be looking fine. I want some pics. This is a grown man. Did the picture come up? The picture didn't come up. There, this is a grown man who's hitting on teenagers that he's supposed to be protecting. And this is my favorite. It's probably a bad idea to send sexually harassing texts to someone you're supposed to be protecting. This is a little bit the same. And you may recognize this guy from Making of a Murderer. He's the prosecutor that was in Making of a Murderer, was Netflix presentation or series. And this guy, I just have to read these things. So there was a woman, again, in his office that his office was supposed to be protecting against abusive situations. And he says, are you the kind of girl that likes secret contact with an older married man? The riskier, the better. And this is the one that really gets me. He says, I have the $350,000 house. Now, keep in mind, this is Wisconsin, okay? Now, he's trying to impress her with the value of his house, okay? Not a garage. I know you guys have $350,000 garages, but this was his whole house. But he's trying to impress her. And he says, you may be the tall young nymph, but I'm the prize. Look at this guy. This guy thinks he's the prize. Incredibly misleading comments. So, at any rate, that's my Hall of Shame. And subject to other questions or comments, that's my presentation. Anything else? Again, for those of you who came in a little late, let me just say that, yeah, I'm sorry, go ahead.
Do you know what actually happened to them in terms of disciplinary action? Like, were they disbarred for this type of behavior? Or,
yeah.
There's another recent Oklahoma Supreme Court case where an attorney was preying on
Uh-huh.
And the decision was he can no longer be in a room alone with a woman, but he wasn't disbarred. So what are, like, in terms of the level of sanction?
Can he be Mike Pence? The question was, what disciplinary action has been taken against people who are lawyers who are predators against people they're supposed to be protecting? Is that right? I'm pretty sure that this prosecutor, first of all, he resigned, I believe that he was suspended for a period of time and until further order of the court, which is an almost impossible burden in Illinois. It's called a UFO until further order. And the Illinois Supreme Court very rarely grants reinstatement for those who have been suspended until further order of the court. I believe that was the sanction for him. This guy from Wisconsin, he resigned, as it said, but he took a long time to resign. This brewed for many, many months, maybe a year or so. And he was recalcitrant about it. I think he wound up losing his job. I think he wound up losing his wife. His mitigation was that he was either an alcoholic or substance use abuser. I think that mitigation permitted him to have a less restrictive disciplinary action. But, the consequences beyond discipline are very significant for these folks. And I do think that, I mean, we like to think that, and by the way, I don't think many states have the kind of restrictions, are permitted to impose the kind of restrictions that you're suggesting from Oklahoma, was it? Where you would be prohibited from being in a private setting with a woman. I think in the disciplinary actions of most states, there can be conditions, but those conditions have to be explicitly pertinent to the practice of law and not a social setting, so to speak, or a setting where you would have that kind of interaction. So I don't think that remedy would be available in the majority of states, but good for them for being creative about it. Yeah. Anything else?